Everyone as talking about the Supreme Court as emergency 6-3 ruling like it is just another headline. But what almost nobody is explaining is what this decision really did. It quietly rewrote the rulebook for how power works in America. Not in 10 years, but what almost nobody is explaining is what this decision really did. It quietly rewrote the rulebook for how power works in America. Not in 10 years. Not eventually, overnight. And that's why millions of people are suddenly affected, even if they can't point to one law that changed. The system changed. Here's the scary part. You want to get a warning label for this new system. You'll just notice weird things happening. A policy is blocked in one place, but not another. A federal agency enforces hard in one state, but backs off 2 states over. Courts start issuing orders that sound like they're talking to each other, and your rights, your real-life rules, start depending on your zip code. So if you want the simple 8th grade explanation of what's happening, stay with me. I'm breaking down the real chain reaction. Lower courts, state attorneys general, federal agencies, Congress, advocacy groups, corporations, elections, and civil rights. And at the end, I'll ask you one question that decides whether this is freedom or fragmentation. Hit subscribe now, because once you see the pattern, you can't unsee it. And you'll understand why this one ruling could shape the next 50 years. Let's make this simple. Before this ruling, when a federal judge didn't like a federal policy, that judge could sometimes issue a nationwide injunction. That means one court order could freeze a policy across all 50 states, even if the lawsuit only involved a few people. Now, this emergency 6-3 ruling slammed the brakes on that. The message is, lower courts can keep using one order to control the whole country the way they used to. Instead of one lawsuit blocks everything everywhere, we're moving toward a lawsuit blocks it only here. And that sounds boring until you realize what it creates, a patchwork. A patchwork means the same federal policy can be stopped in one region but still active in another. That's why people say millions affected overnight. It isn't always one law changing, it's the map changing. And because this came through the emergency process, it moved fast. It didn't come with months of slow public debate. It hit like a switch. Now here's your cliffhanger. If you think lower courts are just going to say, okay, Supreme Court will obey, you're not watching what judges do when they feel humiliated. Because the lower court reaction is where the real drama starts. This ruling didn't just change policy outcomes, it bruised egos. Many district judges have issued nationwide injunctions for years. Some have built their reputations on them. And now the Supreme Court basically said, you've been overstepping for decades. So how are lower courts reacting? Within 48 hours, multiple appellate judges made unusually sharp public statements, basically hinting that the Supreme Court is micromanaging the lower courts instead of giving clean guidance. That is judicial speak for, we don't like this. Then you have the Ninth Circuit, one of the biggest players in nationwide injunction history. It has issued over 40 such orders in the last decade. And now it is scheduling emergency en banc discussions, big meetings where judges decide how they will respond as a group. And here's where it gets sneaky. Legal clerks are reporting that some judges are looking for workarounds. Imagine this strategy. Instead of one nationwide injunction, several judges in different circuits issue multiple matching injunctions at the same time. Not nationwide on paper, but close enough in real life. Some judges are even questioning whether they should fully comply with what they see as the Supreme Court expanding its control over trial courts. That's a deep fight, not left versus right, but top court versus lower court. And it gets bigger. The Federal Judges Association has scheduled an unprecedented emergency meeting where district judges will privately discuss whether they should push back, together. Now watch this. When judges start pushing, politicians don't sit still. They turn it into a weapon. That leads to the next explosion. The State Attorney General arms race. After this ruling, state attorneys general didn't just react. They mobilized. Republican attorneys general in 23 states held a coordinated conference call within hours of the decision. Think about that. Not days, hours. They saw an opening to challenge federal regulations they hate, but couldn't easily block under the old system. Democratic attorneys general responded with their own strategy, filing coordinated lawsuits in multiple friendly places at the same time. The goal is simple. If you can't get one nationwide freeze, you try to build a patchwork shield by winning in many courts at once. Then comes the genius move some people are already talking about. Texas. The Texas strategy is to file in multiple federal districts inside the state. Because even if injunctions are limited by district, if you cover enough districts, you effectively create a statewide barrier. Not nationwide, but powerful. And the arms race is getting expensive. Florida ES Attorney General has announced plans to increase legal staff by 40%, just to handle the multiplied workload of litigating across many jurisdictions, instead of relying on one big nationwide injunction. Now the ugly number. Estimates suggest states will collectively spend an extra $2.3 billion every year on lawsuits that used to be handled with fewer, bigger cases. That money doesn't come from nowhere. That's taxpayers. And it gets even wilder. Some states are forming regional litigation alliances, pooling resources and coordinating filings like shadow circuits. Not official courts, just organized legal teams acting like them. So we now have a reality where policy is being fought in dozens of courtrooms at once. But here's the cliffhanger. While states fight, federal agencies are rewriting how they enforce laws, and that changes daily life faster than you think. This is the part that hits regular people and businesses in the face. Federal agencies used to think we enforce the law uniformly. One country, one rule, one standard. Now that nationwide injunctions can't freeze enforcement across all 50 states the same way, agencies are building a new model. Enforce wherever you're legally allowed. Pause only where you're blocked. The Department of Homeland Security has already issued internal guidance that immigration enforcement can proceed in any place not specifically covered by a limited injunction. That means enforcement becomes state by state, even county by county. The EPA is building regional enforcement strategies. In circuits where injunctions don't apply, they can push climate regulations aggressively. In places where courts block them, they pull back. Same agency, same rulebook, different map. The Department of Labor is preparing similar plans, so you could end up with OSHA inspectors in Alabama ignoring issues that would trigger enforcement in Oregon, not because the science changed, but because the legal boundaries changed. Then the Justice Department creates an internal task force whose whole job is mapping the injunction landscape and advising agencies where aggressive enforcement is legally safe versus where caution is required. And career civil servants, people who joined government to enforce laws evenly, are now getting trained to navigate regional enforcement standards. That's a big cultural shift, from uniform enforcement to strategic enforcement. Now ask yourself this question, because it is the heart of the issue. If agencies can pick where to enforce based on where courts allow them, then who is really making policy? Congress, agencies, or judges? And that brings us to the next problem. Congress could fix the chaos with clear laws, but Congress is doing what Congress does best, avoiding the hard vote. This ruling doesn't just change courts, it exposes Congress. Moderate senators from both parties are drafting ideas to restore some kind of nationwide uniformity. But they face a simple math problem. In the Senate, controversial fixes usually need 60 votes, and neither side can get there. The House is even worse. Some members celebrate the ruling as federalism and local control. Others call it a civil rights disaster that makes compromise legislation almost dead on arrival. And here's the sneaky part. This ruling gives both parties an excuse to dodge responsibility. Now they can blame injunction geography for policy outcomes instead of writing clear laws. Leadership on both sides is quietly relieved. Why? Because they don't have to whip votes on divisive issues if they can just let lawsuits play out across circuits. It becomes not our fault, even though it's literally their job. And yes, Congress created part of this mess by passing vague laws that need judges to interpret them. Now Congress uses the chaos as cover to avoid passing clearer laws that could actually solve it. If Americans realize their elected officials prefer court chaos over legislative clarity, approval ratings, already low, will drop further. Now here's the cliffhanger. When Congress won't act, other players rush in. The next group is already celebrating, fundraising, and hiring armies, special interest organizations. This ruling created a gold rush for advocacy groups, because if one lawsuit can't freeze policy nationwide, then groups now claim they need to file cases in dozens of jurisdictions. And that means they need money. Lots of it. The ACLU announced a $200 million litigation fund focused on coordinated challenges across multiple circuits. Conservative legal foundations are matching that energy by telling donors they will challenge federal overreach in every favorable district available. Public interest law firms are hiring regional specialists, lawyers who know the judges, rules, and quirks of specific circuits. Small organizations are turning into legal armies. The Heritage Foundation has published a 300-page playbook identifying which judges in which districts are most likely to issue favorable rulings on conservative priorities. The Center for American Progress is building similar strategic maps for progressive causes. Here's what's troubling. Well-funded groups can litigate everywhere. Grassroots groups and normal people can barely afford one filing. That creates a justice system where your ability to protect your rights depends on whether a wealthy organization decides your case helps their agenda. Law schools are reacting too. They relaunching new certificate programs in strategic multi-jurisdiction litigation, basically training lawyers to forum shop legally and efficiently. And now even public interest work becomes lucrative. Starting salaries rise as firms compete for people with circuit-specific expertise. So advocacy groups are stronger, richer, and more strategic. But you haven't seen the most sophisticated players yet. The next group is treating this ruling like a map of loopholes. Corporations. Big corporations are not panicking. They're planning. They're treating the patchwork system like a menu. Pick the place where rules are lightest, then structure operations to land there. Pharmaceutical companies are already discussing moving research and manufacturing to states where FDA injunctions are most protective. Tech companies are restructuring to claim they operate primarily in circuits where data privacy enforcement is blocked. Banks and financial institutions may be the most advanced. They have teams mapping every federal rule against the injunction landscape to decide the best place to base different business lines. And here's the irony. Businesses used to complain that nationwide injunctions created unpredictability. Now they exploit the predictability of a patchwork system to regulatory shop. They can avoid compliance while technically staying within the law, depending on geography. Tax strategies also shift. The same business activity could be heavily regulated in California, but barely touched in Texas, based on which injunctions apply where. Economic development officials in business-friendly states are now marketing themselves using favorable injunction patterns, basically promising companies less federal heat if they locate there. And small businesses? They can't play this game. They don't have giant legal departments. So patchwork enforcement becomes a competitive disadvantage. Big companies optimize. Small companies absorb the risk. Now ask the big question. If a company can choose which federal laws apply by relocating, is that federalism, or is that corporate America writing its own rules? And if you think that's scary, wait until you see what happens when elections are run under a patchwork of rules. That's the time bomb. This ruling sets up a nightmare for the 2026 and 2028 elections. Election rules that people thought were settled could now vary by district, depending on which injunction applies where. Secretaries of state may receive conflicting guidance about whether federal election laws apply uniformly or are modified in certain areas. That means you could see different voter registration rules, mail ballot procedures, early voting access, and ID requirements, not just from state to state, but inside the same state. Now imagine the confusion. People in one county follow one rule. People 2 counties over follow another. Both think they're obeying the law. Both parties are preparing armies of election lawyers to litigate in every swing district, because limited injunctions could create favorable voting conditions in counties they need to win while leaving unfavorable rules in place where opponents are strong. And the nightmare scenario is election night 2028 results. Contested based on claims that voting procedures varied improperly within states because of geographic limits on injunctions. That kind of fight doesn't just threaten one race, it threatens trust. But they're a group that may lose the most in a patchwork system. People who relied on broad federal protection, the civil rights communities. For decades, one promise held a lot of America together. Federal law should protect your rights no matter where you live. This ruling puts pressure on that promise. Marginalized communities that relied on broad injunctions now face a new reality. Justice may require fighting the same battle in many courtrooms, with no guarantee of consistent outcomes. LGBTQ rights organizations are worried that protections won through broad federal orders might now apply mostly in progressive circuits, leaving vulnerable people in conservative states with less federal recourse. Disability rights advocates fear ADA enforcement may vary by region, meaning accommodations required in one place might be denied in another because of injunction boundaries. Racial justice organizations are especially concerned about voting rights, housing discrimination, and employment discrimination. If broad relief is harder, they may have to file separate lawsuits everywhere violations occur, slower, more expensive, and less predictable. Civil rights attorneys warn this could reverse decades of progress, forcing people to relitigate battles they believed were already won, and creating safe havens for discrimination where favorable injunctions don't exist. And when rights become conditional on geography, the country doesn't just disagree, it fractures. Now step back. This is not just about one emergency ruling, it's about the direction of the Constitution itself. This 6-3 emergency decision may become a turning point that law students study 50 years from now. Why? Because it signals a shift away from the post-New Deal idea that federal power should be broad and applied uniformly nationwide. Instead, it moves toward a neo-federalist vision where states and regions have more autonomy, even in areas that used to be run mostly by federal standards. Future historians may mark this as the moment when the legal system openly acknowledged that uniform federal law is no longer the main goal. Instead, a patchwork becomes normal, rights and regulations varying based on geography and judicial politics. That does not automatically mean good or bad, but it does mean different. It means you may have to think about law the way you think about weather, not just what is the rule, but where am I? And the most important point, this is the beginning, not the end. The battles ahead, between courts, states, agencies, Congress, advocates, and corporations, will decide what kind of country we become. Lower courts are exploring pushback. States are launching a legal arms race. Agencies are building regional enforcement maps. Congress is hiding. Special interests are fundraising. Corporations are regulatory shopping. Elections face patchwork chaos, and civil rights protections may depend on geography. If you want updates as this story develops, subscribe now. Hit like so more people understand what's really happening. And comment this: do you see this as federalism and local freedom, or as national fragmentation? I will be back soon for the next video. Till then, keep supporting and taking care.